Hi everyone, my name is Kelly Mata. I am an estate planning attorney in South Florida. I own my own law firm called Flex Legal, and we specialize in estate planning for families with disabled loved ones, special needs planning, and in this series we are going through my own personal estate plan. My husband and I are putting this plan into motion, and each day I have been posting a new video talking about an additional document that I'm going to be including in my estate plan. If you haven't seen the first three, please check out my page and you can get all caught up. Today we're going to talk about the financial durable power of attorney. So a power of attorney really is just granting someone to act on your behalf. Sometimes that can be a healthcare power of attorney, which we are going to be talking about a little bit later. I do have healthcare directives listed on my estate planning checklist here. A financial power of attorney is someone who can make financial decisions on my behalf if I'm unavailable and unable to do so for myself, maybe due to incapacity. So in this case, we are talking about a financial power of attorney. What makes it a durable power of attorney is that this document is going to survive in the event that I become incapacitated. In fact, I only want it to apply if I become incapacitated. So I don't want anyone else to have access to my financial records, my financial accounts, to act on my behalf without incapacity. So this is really going to be, it's called a springing financial durable power of attorney. It will only spring into being at the moment that I'm determined to be incapacitated. At that point, the document will become effective, and whoever I appoint as my power of attorney will be able to make financial decisions for me, assist with paying my bills, make sure that my investments are handled properly. This document, it is important to note that different financial institutions require it to be re-signed pretty regularly. They consider it stale. That's not a legal issue, that's a bank policy issue. So you might want to check with your banking institutions, see what they require when they say that a durable power of attorney has gone stale. That might be 6 months, that might be 3 years. It really is bank to bank, so it does vary. But this might have to be updated regularly as I manage my estate plan. And when we get to the end of this series, I am going to talk a little bit more about how we are going to revisit these documents as I get older, as my children get older, and as my son's needs change. So that conversation would fall in that section. So I am going to be assigning my husband to be my durable power of attorney in case of incapacity, but I'm also going to have successor power of attorney listed. So if something were to happen to him before something happened to me and I became incapacitated, we would have a backup plan. I am in the business of what if. So we are going to answer those what if questions in this document. I'll be drafting that today, and then I'll meet you back here tomorrow and we'll discuss the pour over will. Thank you.